Appealing a conviction in Oklahoma, processes and procedure. I'm Tulsa attorney James Worth, and that's the issue that we're dealing with. So we've got somebody who went through a criminal matter, went to a trial, usually a jury trial, sometimes a bench trial, ultimately was found guilty and sentenced, and they want to appeal that. Okay, so an appeal from that stage is called a direct appeal. It goes to the Oklahoma Court of Criminal Appeals. Unlike in the civil area, in the state of Oklahoma, where you've got two levels of appeal. You can appeal to the Oklahoma Court of Civil Appeals and then to the Oklahoma Supreme Court. There's only one option on the criminal side. You appeal to the Oklahoma Court of Criminal Appeals, and that court is not under the Oklahoma Supreme Court, but is separate from that. And any appeal from that point forward actually have to go to the United States Supreme Court, which is very unlikely to accept any particular appeal out of the state of Oklahoma. So we're talking about a direct appeal of a criminal conviction in the state of Oklahoma. Those can be very complicated in the rules, and the Oklahoma Court of Criminal Appeals is very unforgiving. So you're certainly going to want to have representation from somebody who has done these before, knows how to do them well, but I can give you the general layout of the process. So first thing that you've got to do is you've got to file a notice of intent to appeal, and that's got to be filed in the trial court within 10 days of that judgment and sentence. Only 10 days. If it's 1 day late, this is jurisdictional. They're going to dismiss your appeal. So cannot be late. And then after that, you've got 10 days to file a certified copy with the Oklahoma Court of Criminal Appeals. Attached to that notice of intent to appeal needs to be a designation of record. And that designation of record needs to list all of the items from the court record that you want on that appeal, anything that's going to substantiate why you believe you're entitled to relief. So it's definitely going to include all the exhibits, the transcripts, those types of things. So you're going to need to get with the court reporters to get them paid for what it's going to cost to get the transcripts, have them sign off on it. It's a whole deal to get that designation of record done. And again, that's got to be attached to the notice of intent to appeal that's filed within 10 days. So you don't have a lot of time for that. Once that's filed and you pay the filing fee with the Oklahoma Court of Criminal Appeals, which I believe is $300 if we're talking about appealing a jury trial case, then a certificate of appeal is filed by the Oklahoma Court of Criminal Appeals noting that received your notice of intent to appeal, designation of record, and filing fee. Then the next thing that's got to be filed is your petition in error. And that's where you're listing all of the issues that you believe where the law wasn't properly followed, or where the court maybe acted in a way that was against the evidence, or if it's a jury trial, it could be a little bit different. But any of the errors that you allege occurred during your trial, how your rights were violated, how you didn't get a fair trial, you're going to list those out one by one in there. And then when you file your brief later, it's going to match up with that list to have separate propositions of error. So that's got to be filed within 90 days from the date of the judgment and sentence. And this is where it can get a little bit tricky, is the next item on here, because that is the notice of completion of record. So once you pay to file with the state court, they charge you a fee there. They charge you a separate fee with the Oklahoma Court of Criminal Appeals. You pay a separate fee to all of the court reporters to get those transcripts together. Then the trial court is supposed to get all that record together, and then they tell the Oklahoma Court of Criminal Appeals that it's ready by setting in a notice of completion of record. Then within 10 days of that, the Oklahoma Court of Criminal Appeals says, okay, go ahead and send the record over. But here's the deal. If you are an appellate attorney who did not handle the trial, you want to be able to review the transcripts and everything before you know what errors to list in the petition in error. But both the deadlines on those for getting the petition in error done and for getting the notice of completion of record is 90 days. And sometimes the court clerks are late in getting that done, and the court will not hold it against the court clerk if that doesn't properly. They hold it against the defendant or whoever appealed. In this case, in most cases where we're talking about criminal convictions, that's going to be the defendant. So as the attorney for the defendant, you have to follow up to make sure that that gets done, get it as soon as possible to review it, make sure you don't want to add any additional petition in or errors for that petition in error. Okay, and then, so then they transmit that record. Next thing is going to be the appellate's brief. That is the most important part. So that is, you've reviewed the record and everything, you know what your listed errors are, and then you are drafting out, writing out persuasive information, incorporating arguments and facts from the case to demonstrate that errors occurred that were prejudicial to your client. And that's got to be done within 60 days of the notice to transmit the record on appeal. As a practical matter, if you request an extension before that deadline is up, it's not unusual that you would get at least one extension, sometimes two extensions. You know, don't want to abuse that process, but what it's important to note, these deadlines are not jurisdictional. So you're not automatically going to be dismissed if you're a day late. Don't be late. Request an extension if you need one, but don't be late. But it is a little bit different standard than with the notice of intent to appeal that's jurisdictional, where the court says it lost jurisdiction at that point. So they're like, hey, would love to cut you a break and continue to handle this appeal, but just not allowed to. We lost jurisdiction. We didn't file it in time. So do try to set those deadlines, but also note the distinction between those two types of deadlines. So once you get your appellate brief in, then the appellee, meaning the state that you are appealing, state of Oklahoma, has 60 days to file a answer brief. And then from that point, you've got 20 days to file a reply brief if you want. You can request a motion for oral arguments. Those are generally denied. The court hears very few oral arguments for a direct appeal. It's almost always based just on the record and the briefs filed by the parties. And once you get those briefs in, at that point, the court takes a little bit of time to make their decision. So you can expect that decision anywhere between 6 months and a year and a half would be typical. And sometimes they're more delayed than others. Some cases take longer than others, and I'm not sure why, but that's just what we see there. So that's kind of the nuts and bolts of it without too much specificity. If you're dealing with the circumstance, though, you're definitely going to want an experienced attorney who has lots of time and experience handling these types of cases, because lots of things can go wrong on those appeals. So if you're dealing with that, talk to an attorney, get legal advice specific to your circumstances. To get that scheduled with an attorney at my office, you can go online to makelaweasy.com.